It is June 17th of 2026, and this is the Court Gallery. Today's lineup is a masterclass in how to make your own life infinitely harder. First, Judge Aquilina presides over a messy nonprofit defamation dispute where a mayoral election lay in ruins. Then, Judge Webster handles a missing defendant who shows up late with horrible excuses and a fresh bench warrant. Next, we join Judge Middleton and watch as a simple traffic stop spirals into a 3-day jail stay all over unnecessary backtalk. Finally, Judge McNally is enraged by the details of a shocking drive-thru assault and gets an earful from a frequent flyer. Grab your coffee, this gets wild, and it all starts right now.
For CZ, Huntsman Lunch, Lansing, and Kelsey Hector versus Derek, Ruth, Martin, Sean, and Julia. How's your experiences?
Elizabeth Abner for the plaintiffs.
Catherine Fleming for Huntsman Lunch as the counterclaims only.
Mark Sodori on behalf of Defendant Julia Miller only.
Martin Michigan and Bill Burke.
All right, thank you. You may be seated. And this is Marshawn's motion for several sanctions and to strike. Counsel, you may serve for me proceed, and you're not a lawyer, correct? You're not a lawyer, correct?
No.
Okay, well, you can represent yourself, so you need to come up here. All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Absolutely, yes, ma'am.
Yeah, I think we should go through the formalities. Please state, spell your name for the record.
Martin, Martin, Michon, Mashon.
What would you like me to know, sir?
Good afternoon, ma'am. Thank you for having me today. And today I'm here to present an omnibus motion. A motion for summary disposition, motion for severance, motion for sanctions, and motion to strike, if need be. I would like to go through those in that order.
You may.
The places. Thank you. In regard to summary disposition, the defamation claims from the organization and Kelsey Hector, they've got to be dismissed. Truth is an absolute defense. My statements that have been made against the organization of Kelsey Hector have been rooted in fact, as evidenced by their own pleadings.
Well,
yes, ma'am.
Let me just stop you right there.
Yes, ma'am.
You're disputing some of that, is that correct?
Yes,
Yes,
correct.
okay.
We're disputing some of what Mr. Michon is stating right now, Judge.
Well, he's saying that it's that in your own pleadings you've agreed to what he is saying, but that's not in fact what I read. Are you in agreement?
I'm not. If we could talk about what the specific items are that that he's alleging we are or not in agreement, that would be helpful, Judge. I'm not sure what he's referencing.
Because here's why I'm asking and interrupting you, sir. While you may assert, and keep in mind, I know some things about this case, but that's why we have trials. I don't know everything, and I'm not the trier of fact. That is the jury. I decide what the law is. And so if there is question of fact, then it has to go to the jury, not me. So even though you assert it's true, if they say it's not true, we have a question of fact, and it goes to the jury. So that would be inappropriate for me to dismiss. Does that make sense to you?
Absolutely.
So the question then is, which is what her question also is are you asserting that they've agreed to everything, so there is no issue of in dispute, or are there some statements that are disputed? So
I do apologize. I'm not sure.
Well, you're saying that in their pleadings they've agreed to everything, right?
No, ma'am, I do apologize. In their pleadings, they have stated essentially the statements that I've made, and they've attested to in their own pleadings. I've statements about financial mismanagement, embezzlement. These are all statements that they made in their pleading, in their counterclaim against me. They've made clear that there was embezzlement, there was fraud, there was financial mismanagement. Me stating such as a matter of free speech in regards to a nonprofit, publicly funded organization.
Well, let me stop you there.
Yes.
So you're saying they did certain things and they're saying you did certain things, correct?
Yes, ma'am.
Okay, so that's a matter that's in dispute that would go to the jury. There's no agreement as to what you all said. You're in dispute on those points, aren't you?
In dispute on.
Well, you're saying they're saying that you embezzled. You're saying they embezzled, right?
No, ma'am, they're not asserting that I embezzled at all.
Okay.
Not at all. No financial mismanagement on my part. No embezzlement. No. There's nothing of the sort.
What are you asserting against him that is in dispute?
Judge, so what I think he's saying is that we're potentially in agreement about what one or more of the other defendants may have done, which is not a basis for summary disposition by him.
Okay, so you're talking about other people then.
Right.
You two are in agreement with what other people did, sir. Is that correct?
It is.
So then what
seems
is
to be factual?
Okay, but then what is the summary disposition issue that you want me to dismiss that specifically relates to you, not others?
Yeah, absolutely, ma'am. So they have asserted that I committed defamation. However, Punts with Lunch Financing is a publicly funded entity, a nonprofit, and therefore, First Amendment clearly would protect one against acknowledging their own statements, even publicly, about embezzlement within the organization. They're asserting that I called them embezzlers and mismanaged. However, they assert that themselves in their own complaint. Additionally,
That you mismanaged or somebody else?
that other people mismanaged at Punts with Lunch.
I want to know what's related specifically to you, not to these other people. I really don't care what they asserted about other people. Maybe I should hear from them first. What's your dispute with this gentleman?
So specifically that he made hostile and derogatory comments about the executive director in particular, and some about the organization.
Okay, so let me just stop you there. What or how has that affected Punks with Lunch? Because there is some free speech components. There's also components, counsel, that have to appear where it has negatively affected and people took it as true, and there's a lot of other factors. So how have these alleged statements affected anybody?
So with respect to plaintiff Hector, there were comments that were made during the time she was running for mayoral. I think it was a primary. And so
what? Can you identify that her votes went down because of what he said, or there was any other action? I mean, political campaigns are what they are, and people say all sorts of things. Can you directly say that she didn't make it or lost a segment of votes because of anything he specifically did?
We would intend to try to
not what you intend,
discovery, Judge.
Ma'am. Not what you intend. I want to know what you can prove. You don't know?
Without discovery, we don't have proof of that, but we have reason to believe that it may have occurred based on information that we've received from individuals that she's spoken with. So that's the information I have at this point, Judge.
I'm not interested in people off the street. Have you talked to any of the voter people, Secretary of State, anybody, campaign commission, or any of the commissioners who deal with these numbers? Or is this speculative at best?
Judge, without the ability to get those people to a deposition, they're not going to give me information about that. I can also say that there was the organization believes that they've lost money due to donations going down because of some of the comments that were made by Mr. Michaud. And again, that would require having to depose folks and find out, what they were, what their intentions were, and why they lost the donations. But
okay, so let me stop you there. Why haven't you done it up to now, or have you done this, or is it pending?
Judge, we've literally, I think we just got the discovery order in place the last time we were here in court. So we're in the process right now of determining where we're going to go with discovery. I also want to point out, Judge, that I sent an email to Mr. Michon on October 22nd to try to get him out of this before he even had to be involved in this matter, and he never responded to me.
So why don't raise your hand? You're not in second grade. I'm going to do this because I know I'm a little out of order. It's not what you expected, but I like to cut to the chase on these things because there's either an issue or there's not. So, ma'am, why are you willing to dismiss it in whatever September, but not now?
I don't know that we were willing to dismiss it. We were willing to discuss with him whether we could reach a settlement in order to dismiss.
Okay, so he doesn't have to talk to you. You're a lawyer. He doesn't have a lawyer. So you reached out. He didn't. So we're in court. That means nothing to me. Do you have anything that means something to me?
Without being able to do discovery at this point, I don't have any evidence for you, Judge.
Thank you. Okay, sir.
Yes, ma'am.
Okay. So, is this the crux of what you have to tell me that you didn't do any of this stuff? They can't prove their case.
Essentially.
Okay, stop.
Yes, sir.
Okay. How much time do you need for discovery?
I believe we already have a
I
discovery.
don't want you to believe. I want you to know.
Okay. 2 months.
Okay. So here's what we're going to do, sir. I'm going to hold this motion of yours in abeyance and let them have their depositions and they can spend their money and do whatever it is they need to talk to their people and get some figures. If they cannot prove their case, this will be dismissed and I may consider sanctions. But I'm not going to do it today because they are entitled to some discovery. I don't know that this is hurting you to keep it open. Neither one of you should be talking about each other or this case. We should just need to see if there's evidence or not evidence.
Acknowledge, ma'am, if I could state, there is harm in me remaining on this case. I am a FINRA registered representative. And a FINRA registered representative, I deal with annuities and financial management. This case against me, being in this case regarding primarily embezzlement, has had a profound negative effect on my profession. And
in what way, sir? Because this is only
additional scrutiny and just the from FINRA, which is a federal agency that oversees financial representatives. As the clients have, or as the plaintiffs have also stated, Kelsey Hector was a mayoral candidate at the time. Again, protected free speech regarding political speech. The plaintiffs also bring up about this email that was sent to me on October 22nd. However, the ex parte was already granted on October 21st.
So you're not obligated to talk to them. That's why we have court. Okay.
The motion for discovery, they cannot bring any evidence to the table at this point. They have had now 8 months since filing this complaint.
Well, it looks to me like the scheduling order they're saying was just kind of finalized between all of you. You all have been, there's been a number of changes in this case. So, sir, this case has not been adjudicated. People can file whatever they want, criminally or civilly, basically. And then we have to deal with all this. And there should be no negative ramifications regardless. Even doctors who are brought up on malpractice or criminal charges often get to practice until there's an adjudication. So there's no adjudication on you. So I don't know how it's negatively affecting you, but we're going to shorten some time frames here. Yes?
I do also have one additional critical piece of information. At our last hearing, back in May here in this courtroom, Kelsey Hector testified directly to you in this court under oath that the Attorney General, Michigan Attorney General, was actively investigating this embezzlement complaint. I have here, and I would like, if you would allow, an additional exhibit, a FOIA request from the Attorney General office, which denied investigating Kelsey Hector's case. In May of last year, she was made fully aware of it. In May of last year, she knew full well that the Attorney General was not investigating the case. And the whole basis of their arguments against me, I mean, it's the factual components of their pleadings are, they misrepresented, essentially. Their assertions.
Have you seen, is that your only copy? Have you seen it?
No, ma'am, I made 3 copies.
I have not seen the copy, Judge, but I can speak to this. My understanding, and I sat in on a meeting with a representative from the state. I don't remember exactly what department he was with. I believe he was with the Department of the Attorney General's. I sat in a meeting with him and Ms. Hector about 3 weeks ago via Zoom. There is an active investigation. What I believe may have happened is perhaps it was closed and reopened, if that was from May of 2025. But I can tell you, I can personally attest that I sat in on a Zoom.
Okay,
I have
please hand her. I'm not going to decide anything
my
today,
fault.
sir. Please hand her a copy. I can't, she hasn't reviewed it. I don't know what she has. She's going to have to, that's why we have discovery. She has to turn over what she has. We can have an evidentiary hearing as to who lied or who didn't lie. So y'all can figure that out. And you can set, sir, an evidentiary hearing. That's going to take an evidentiary hearing.
Yes, sir.
So at that time, you can introduce that. You can show that she lied to the court, be sanctions and other things. Maybe she needs to get a lawyer. I don't know. Maybe you need to see what they have. There should be an exchange of information. So we are going to, I'm going to order that by September 18th, everybody's deposed to see whether there is evidence or not. And should there not be evidence, he needs to be discharged from this case. If he is not, I promise you there will be sanctions, because we cannot bring people and ruin their lives under things that are constitutionally protected, and there's no basis to show a significant loss in voting or anything else. That is blatant constitutional violation, and making assertions that you can't prove is also an ethical violation. So let's not go there.
Thank you, Judge.
Thank you.
So, sir, we're going to, after that closes, what you need to do is contact my office for a date. Maybe you all can agree on a date sometime in October. We'll have a hearing, and we can have an evidentiary hearing in regard to that issue of whether she told the truth or not. And if she did, let's move past it and get you out of the case if that is, or keep you in, and we'll get this case to trial. Any other issues we need to address for today?
That's it for the summary disposition. That is it. However, there's also a motion to separate.
No. And I'll tell you why. Why would we separate it? I'm going to hear from the same people in the same situation. It's going to cost everybody more money and cost more time on my docket. As we get later into discovery, if you show me that there is going to be different witnesses, different proofs, essentially a different case, then I am willing to sever the case. But right now, it does not look that way to me, and I'm not going to waste time and resources.
Ma'am, if I may, please, just briefly. Now, if these are functionally, we're dealing with 2 completely different lawsuits. I am counts 1 through 5 and 8 of this complaint deal exclusively with financial mismanagement, investment against the other 2 defendants. I am stated merely in 3 counts for defamation and intentional infliction of emotional distress. It's extremely prejudicial in front of a jury to have these pleadings about financial mismanagement mingled in while I'm sitting at the same table with the defendants. Additionally, both of the other defendants physically assaulted me in August of 2024. One of the co-defendants is still on an active court order, no contact with me. It would be egregious, I believe, to have me sitting at a table with 2 assailants of mine.
Did you file a police report? Is there a criminal case open?
Absolutely, ma'am. If you want to refer to the omnibus motion.
I don't. Okay. Again, sir, I will consider severance after this discovery and we see where it's at, because you might very well be out of this case and then we're done, right? We don't need to sever if you're out of dismissed, correct?
Acknowledge.
So I think we can do it very easily if we'll see what they can or cannot prove. And then this case may all go away. I just need to give them some proper time, you to look at what they have or don't have, and then we're going to revisit this.
The continued impact on my employment being tied to an embezzlement case, ma'am, as a financial representative, this is devastating career-wise.
Well, have you been demoted?
No, ma'am.
Have you lost pay?
No, ma'am.
Have you lost any time?
Yes, ma'am.
How?
Having to.
No, not
notice
this.
for-
Everybody loses time in a case. I mean, through your employer, have they cut
Oh,
your time or anything?
absolutely. And the days following being the news, the media breaking, I had to take some mental health days off.
Okay, I get that, but your employer didn't do anything negative to you.
Not at this time.
Okay,
I'm under much
it-
more scrutiny. I'm
it's-
having an inspection next week. I'm not like,
Well, it's not right for me. If you keep track of all that, that may very well go to sanctions and how we handle the rest of this case. Get to what you need to if you're affecting his ability to earn a living. That will cost. Let's figure this out.
Thank you, Judge. And just to be clear, we don't have him named on any of the embezzlement counts. So
I understand, but I think what's happening is because of so much fraud and other things going on in the world, him being tied to it is somehow affecting him or triggering it because they're thinking in their heads, right or wrong, well, he must be tied to it somehow. So I'm just saying, let's get to it. And if he needs to be out of this case, let's get him out.
thank you, Judge.
thanks.
Mr. Belladori, did you have anything for today?
I do have a comment after Mr. Machado is completed here.
Okay, so your issues are going to be held in advance until after this discovery, and then we're going to deal with all of them, have an evidentiary hearing if we need. So we're just going to postpone this until we'll probably get your date in October. I just don't have the calendar, and I want to make sure you're both done because based on what they do in the discovery, you might even need an extension. So let's see where we are, and then I'm going to handle all your issues. Okay?
May I address, please, the sanctions due to the abusive process? That is something that is irrelevant.
Sanctions are preserved, and we will talk about that at the end.
I'm sorry, it was in regards to the process of the court, them filing the ex parte order, essentially planning a media hit a week before coming to this court, asking for an ex parte order, having the media drop headlines the same day this court grants an ex parte order, and then they didn't even get a summons until after the election in November 4th. They didn't even get a summons for the ex parte order until November 12th.
Sir, I'm going to deal with all of that at the end because they've heard what you have to say. They're going to have to respond. We're going to have probably an evidentiary hearing and I will see who gets sanctioned, who doesn't. I cannot piecemeal it because this is also going to take an evidentiary hearing. So you're saying this, they're going to say exactly the opposite and they don't have any control over the media. So whether they planted this or not, perhaps this part of the discovery you want to do so I can have a full lay of the land, sir.
Ma'am, I have included all the evidence right here in this motion regarding the emails from the reporter on October 14th and 15th, where they acknowledged receipt of having this complaint. Where a week before the plaintiffs even came to the court asking for an emergency order on this court. And then they waited a whole nother week and a half even to get a summons. During that time, media is throwing all these things out here, literally with headlines stating co-founders of Punks with Lunch accused of embezzlement. I am a co-founder of Punks with Lunch.
Did they name you specifically?
I was absolutely named in those articles.
Do you have a response to that?
Judge, first of all, I have no control over what a reporter writes. What I can say is,
Did you or your organization pre-send out before filing with this court publicly documentation to any media outlets?
we responded to requests. I don't remember the exact dates off the top of my head. I do get a lot of media requests.
Okay, I suggest you get your ducks in a row and get all of that to me because if there's merit to this and you've set them up to publicly be humiliated, I will consider that in sanctions. So I don't know, but again, that's going to be part of the discovery because
I have proof here.
Sir, you have proof. That's half of the case. I need them to respond and they're going to tell me that didn't happen or maybe it did. But she's saying I have no proof of this, that, and the other thing. So we're going to make that part of an evidentiary hearing as well. So I can't go forward today until they also have their proof. So this is going to be part of discovery. Everybody get your timeline and evidence in order. And this is a court who will sanction. So it's needed. I can't predetermine anything, but I think we need on both sides more information. I don't want you to believe, I want you to know. And if nothing's there, that's going to tell the story. So both sides, get everything together.
Absolutely. They'll be liable for the financial damages.
We'll see. I'm not making predetermining anything. I'm going to look at the evidence what you present on all of the issues. You have them in front of you here. Let's get all the discovery of those depositions together. And you might want to have a few of your own as to what happened and didn't happen. Assertions are one thing, evidence is another thing. Because
Man, I've got evidence. I have emails.
Sorry, you've given it to them and
The omnibus motion has the emails right in there from the
Have you looked at what they filed?
they filed a response.
I got it, sir. Have you looked at what he filed?
Yes, Judge.
And did you do those things where you sent out things to cause immediate bliss that negatively affected him?
I have never in my career done anything to intentionally cause a media blitz.
Did somebody?
My best recollection, Judge, is that there was a reporter who was following the case who had asked what the status was. I do sometimes send out complaints before we file them. There was no intention to cause harm to Mr. Michaud.
Why would you do that? So that you get a media blitz before filing a public document?
What I can say is, it's a common practice.
It's not a common practice, counsel. It's probably a violation of some kind of ethics.
And I am not aware of any ethics related as a violation of, Judge. We were sending out the document that we were going to file because the reporter had asked to have it so that they could write the article.
So you're giving the media documents the court doesn't have, the other side hasn't been served with, so that you can have, a day in the public instead of a day in court? You don't think that's a kind of a backdoor violation?
I can say if you were to interview probably 100 plaintiffs' attorneys in this courtroom, I guarantee at least 50 of them would tell you that they're doing that. So, perhaps we need another.
Are you telling me that makes it right? That's not. Whoever's doing that, stop.
Okay.
Don't do that. Because what if the assertions you haven't even done discovery, and what if you never file it? Now you have defamed someone. I find that problematic. Maybe you all don't. I think it's a problem. But again, sir, I want to know exactly what they have, what they did, what they didn't do, what she sent out. Give her an opportunity to respond to it. We're going to have an evidentiary hearing. This is going to take more than 15 minutes. These motions are 15 minutes. This needs to be set out for a couple of hours. Find a time on my docket. I'm going to hear it all, make a decision. You don't like it? Court of Appeals down the road. Everybody clear?
Thank you, Judge.
I want what you know. I don't want what you believe.
The data from the document came from her office, produced in October.
But we may need to have in the reporters, whoever she sent, the problem with all of this is that the reporters are going to say, I can't tell you my source.
Mm-hmm.
So we're going to have to deal with all that, and counsel may end up needing their own attorneys because they're going to be witnesses as to what happened. So sort it all out, counsel. Mr. Milbury, what do you have for me?
Yes, just a couple things, Your Honor. Administrative, I have a stipulation for Defendant Julia Miller to file a cross claim against Defendant DeLuca. So I have the proposed order right here. I have the signed stipulation.
You signed it to everybody?
So Mr. Michaud was refusing to stipulate, but what I looked at, I refreshed my memory of the court rules, and really I only need the adverse parties signature, meaning the plaintiff. So I got that as the timing approach.
You've also signed this?
It's our attorney for plaintiffs has signed it. That's the stipulation, it's the order.
Sir, what they're doing is filing leave to appeal to file a claim against you, and they're asserting essentially financial misconduct. Again, they're going to need discovery. So do you have a copy for him?
Yes, I've emailed him copies. I have another copy at my desk. I can get.
Oh, okay.
And it's actually against the other defendant, DeLuca.
DeLuca.
Yeah, he's the appeared a party that has not appeared.
Okay, the guy that has. Okay, I'm sorry.
All good.
Not this one. So again, there's no counts against him in regard to this mismanagement.
Correct.
So that's good. All right, we're gonna get you all copies for this. Would you please make copies? All right. When you schedule your hearing, your evidentiary hearing on both sides, we probably need an hour or two, but I will make a note of this.
And
all issues are reserved.
Thank you, Your Honor. One thing is just my understanding, just for the record, two things for the record here. Mr. DeLuca has already been personally served at the 3900 Burn Way Drive, Apartment 316, Lansing, Michigan. That's where we will be serving him with the cross claim.
Okay.
Because he's already been personally served. My understanding is part of the same case. He can be served at that address now. The second thing is, as a discovery, as indicated on the record today already, there's numerous intentional infliction of emotional distress counts relating to the complaints against my client Julia Miller. I've made numerous requests for basically medical authorizations to help us do discovery and get to the bottom of emotional distress, et cetera, on behalf of the plaintiff, Kelsey Hedger. I've received absolutely no response to that. I've been requesting it for months. I'm placing it on the record to place it up further on.
You got 30 days to provide it, otherwise it will be deemed admitted, and it's just going to go to damages.
Okay.
That's unconscionable. We're not going to have delays in this case because you're all not prepared or you believe. I always say, take your beliefs to church. Got evidence? You're all trained counsel. Evidence, court rules, deadlines. Counsel, you got 30 days. Day one starts tomorrow. If you don't have it in 30 days, it's admitted, and we'll look at damages. Thank you.
Thank you so much. Nothing further.
We are on the record in BU 2025 TR 1797, State of Kansas versus Chanel Tremaine Williams. Please announce appearances.
Jeremy Gay on behalf of the state.
And I'm looking for Attorney Stein, Philip Stein for Chanel Williams. Ms. Williams, it does look like Attorney Stein has entered a formal appearance indicating he's representing you, but I'm not hearing or seeing him on here. Oh, there he is. Mr. Stein, can you join us by... Where'd you go now?
Morning, Judge.
Good morning, sir. All right, so we are here for Ms. Williams on the charges of tag violation, no insurance, and driving without a license, which said, I believe, for judgment on bond today.
Andrew, if I may.
For you to report Monday, June 22nd at 1:30.
Okay, I'm picking up somebody, but I can't tell where that's coming from. Is that coming from Mr. Stein or the clerk?
I don't think it's me, Your Honor.
Okay, so Mr. Regier?
Your Honor, this is a case where it would appear that there were multiple failures to appear back in October of 2025 and February of 2026. More recently, approximately 1 week prior on June 8th, it would appear that the defendant finally did successfully appear before this court after the state had filed a motion for judgment on bond on May 13th of this year. State's information is that the court did grant the motion for judgment on bond at that setting, and that an order for judgment on bond was filed with the court approximately 2 days prior on June 15th.
All right, so now then we need to proceed on the charges. Mr. Stein, how does your client want to proceed?
Judge, so here's the deal, and I'm a little bit at your discretion. I've entered my appearance. I can tell you I'm familiar with Miss Williams. I've represented one of her family members and I'm currently handling his case in Johnson County. Miss Williams came to me because she picked up a traffic citation in Johnson County, which I entered on. We realized that there was a hold out of Butler County. She did not have the resources to hire me at that time, so I advised her just get a hold of Butler County, take care of that matter. She came down, and I know she had multiple email contacts with the jurisdiction, came down and appeared before you, and at that time she was placed into custody on a no-hold bond because of her failures to appear. I've been working with the state, and we do have a plea offer on the table. That being said, Judge, my client is diversion eligible, and so my hope was that we could make application for diversion, but in order to facilitate that, Judge, I'm sort of requesting a bond, which I understand is a big ask given her track record, but I'm now entered my appearance, and I can assure you we will be not failing to appear and getting the matter resolved. I would like to make application for bond if my client's able to get out today, because she does have a job and she has some medical issues that are pretty concerning if she remains in custody. If you're not inclined to grant that bond request, we would proceed today. We do have a plea offer, but I hate to take that plea offer if we can apply for diversion, because it would cost her license, which will further set her back. So I'm just kind of coming hat in hand to you and determining what you're willing and able to do at this point.
All right, Mr. Laguerre, what is your response for the state? To first of all, setting this over for her to apply for diversion, what's your response to that?
Your Honor, it would appear that the court had previously set a subsequent hearing date in this matter on August 31st. Insofar as the issue of diversion is concerned, state's information is that diversion information can be found if that is something the defendant wishes to pursue. At this time, I cannot say one way or another whether or not this defendant would conclusively qualify, as I'm not in the business of pre-qualifying people for diversion, only that there is that prospective possibility. Insofar as bond is concerned, the state's information is that this is a defendant who had previously failed to appear before the court on 2 consecutive occasions, including after being given the benefit of a professional surety bond in the amount of $2,000, which was seemingly insufficient to secure the defendant's appearance in that matter. If the court, additionally, this would appear to be a case that is fast accumulating a lot of age to it. The ticket in this matter appears to be almost a year old at this juncture, with the alleged stop date occurring on July 26, 2025. So the state does have concerns, given the prior failures to appear, as far as reaching a timely resolution of this matter. However, if the court is prepared to grant modify the court's prior orders concerning bond in this case, the state will wish to be heard at the appropriate time as to an appropriate amount and all appropriate conditions.
So are you or are you not objecting to continuance?
Your Honor, the state is prepared to defer to the court on that issue, given the history of this case.
Jenna, did I understand him to say we have this on the docket for August 31st?
Yes, Judge, we are set August 31st. We can take up the matter at any time before that. I actually just received information yesterday that I believe my client was in fact insured at the time of the citation. So I just need to get documentation to Mr. Aguirre, and then I think this case is going to be very easy to resolve. So I don't know if you're requiring her appearance for that plea, but I think this is likely to be just a traffic citation that we could get resolved by Zoom. So I can assure you that Ms. Williams and I are in regular contact. I was with her family yesterday, and I'm in contact with her on a weekly basis and have been for the past 2.5 years. So yes, we do have a date, August 30th. My hope was to get it resolved as quickly as possible. So I don't know if you have any other settings that you could squeeze us in on between now and then, because we'll get that application for diversion in by tomorrow.
Well, the clerk kind of takes care of that for me because I have such a crowded docket. Jenna, do we have anything earlier than that?
Let me look, Your Honor. July 8th, I can fit it in.
I could do July 8th.
All right, this matter is continued at the defendant's request to July 8th at 9 a.m. Defendant counsel must be back here at that time unless she is diverted. Now, if she's got a diversion application and her diversion contract on file, if those are both signed and filed, then she won't have to be here, Mr. Stein. Nor will you.
Judge, and if the diversion is not granted and she's entering a plea to that no insurance charge, do you require her appearance in person?
I do.
And with mine as well?
Yes.
Okay, understand. We will get that taken care of, Judge.
Again, if you don't have to be here if she's diverted. So
Thank you, Your Honor. I sure appreciate it. And then
Yeah.
regarding bond, I don't know what you're willing or interested in doing.
I'm gonna leave her on the no bond hold. Now, if you guys get that diversion done sooner,
Well,
and
well, I'll tell you, Judge, if you're not going to allow her to bond out, I think we need to go ahead and take the plea up today. We were prepared, so if you're willing to, she's just going to plead to guilty to the no insurance charge. She's going to lose her job if she remains in custody, which was our request.
so your plea agreement is she pleads guilty to count 2, no insurance. What happens to counts 1 and 3? Are they to be dismissed?
Your Honor, the state's information is that previously my office had extended a plea offer in this matter. Upon successful entry of a plea to count 2, the no proof of insurance charge, the state would move to dismiss count 3, no valid driver's license, a class B non-person misdemeanor, count 1 having been previously dismissed by way of amended information.
All right, Miss Williams, I'm pulling up an amended complainer information filed July 31st, 2025. That's one you're referencing, Mr. Regier.
That is the state's information, Your Honor.
All right, count 1, the expired tag has been dismissed, as Mr. Regier said. He is now moving to dismiss count 3, no valid driver's license for plea agreement. That leaves you with count 2, operating a motor vehicle on July 26, 2025 in Butler County, Kansas, upon a public highway or property open to use by the public, while failing to provide proof of insurance upon demand by a law enforcement officer. How do you plead to that sole charge of driving without proof of insurance?
Chanel, you gotta say guilty or not guilty.
Guilty.
By pleading guilty, you're admitting that you were driving without insurance and could not produce it when the officer asked for it.
You gotta say yes or no, Chanel.
Yes.
Do you understand that by pleading guilty to no proof of insurance, you will be found guilty and will not be able to appeal your conviction? Do you understand that?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
All right, I will accept your plea as freely and voluntarily entered to count 2. I find you guilty of count 2, no proof of insurance. Counts 1 and 3 are dismissed on motion of the state per plea agreement. Recommendations for sentencing, counsel?
One moment, Your Honor. Your Honor, pursuant to plea negotiations, the state is prepared to recommend the statutory minimum fine, which the state understands to be $300, that the court impose appropriate court costs and a non-reporting probation. State would specifically recommend a 6-month non-reporting probation subject to a suspended jail sentence of 120 days. State has no objection to the court ordering credit for time served if the court deems that appropriate.
Thank you, Mr. Stein. Anything further before I pronounce sentence?
No, Judge.
Ms. Williams, at this time, I do fine you $300. That's the minimum allowed by law. I also assess 108 court costs, which is a total of $408. How much time do you think you'll need to pay that?
Yes, ma'am.
How much time will you need to pay the $408 total?
What did she say?
How much time do you need to pay $408? How much time will it take you to pay that?
Can I be on a payment plan, ma'am?
How much per month do you want to pay?
Can we do within 3 months?
You know what, I'll give you a little more than that. I'll give you 120 days to get that paid. And you can pay that, yes, in payments. But make sure you have it all paid within 120 days, whether you pay it in a lump sum or payments. Makes me no difference as long as it's all paid within 120 days. And I'm also going to make your jail sentence a 120-day jail sentence. Now, if you don't want to stay in the county jail, I am suspending the remainder of your sentence for a 6-month non-reporting probation. That means you will not report to a probation officer, but you are still on probation for the next 6 months. The conditions of your probation will be to violate no laws for the next 6 months and to pay the total of $408 within 120 days. Do you have any questions about that, Ms. Williams?
No, ma'am.
Now, if you don't pay within 120 days, or if you violate the law within the next 6 months, your probation can be revoked and you can be ordered to serve the balance of the 120-day jail sentence. You have any questions about that?
No, ma'am.
Very well. Contact the clerk of the district court on how to make your payments so you don't forget about that or miss that requirement. Mr. Regier, anything further on this case we need to address?
Your Honor, does the court wish the journal entry to reflect credit for time served if there is the prospective possibility of the defendant serving the balance of the sentence?
That is correct. I want the credit for time served in the journal entry, yes.
Nothing further from the state, Your Honor.
Mr. Stein, anything further?
No, Judge, the only thing I'll tell you is I was hopeful I was going to have the documentation that she had the insurance on the date of the citation. I still provide that to the state. If for some reason we're in a position to be able to file a motion to withdraw, I'll do that, but I don't expect that likely to happen. So
Very well.
thank you, Judge.
And Your Honor, does the court, given the proceedings here today, does the court intend to maintain the August 31st hearing date?
No, I will take that off the docket.
Thank you, Judge.
You're welcome. Miss Williams is remanded to the custody of the sheriff. Mr. Stein, unless you have another case on the docket, you're excused.
Understood, Judge. And she will be released today then pursuant to the sentence. Thank you, Judge. I appreciate that.
That's all right. You're welcome.
Have a good day.
You too. All right. We'll be on the record in the other Kilgore, BU 2026 TR 826, State of Kansas versus Brittany A. Kilgore. Jared Regier for the state. Brittany Kilgore fails to appear on speeding 84 and a 70 and driving without proof of insurance. She did have a citation and uniform notice to appear served on her by the operator. She was told to be here June 17th at 9 a.m. Must appear or pay fine on her before that date. So, Mr. Regier, recommendations?
One moment, Your Honor.
Okay.
Your Honor, in this matter, the state is recommending a bench warrant, at the very least $1,500, cash or professional surety. In addition to the court finding that the defendant fails to appear today, the state's information that this is a defendant who has failed to appear before court in the past on unrelated matters.
The court does issue a bench warrant for the failure to appear and sets bond at $1,500 cash or surety.
30 minutes later.
Miss Kilgore appears now. Yes, Deputy.
This would be Brittany Kilgore. We already took care of Jake.
Jake was the gentleman. Thank you.
Yeah.
We are on the record now in BU 2026 TR 826, State of Kansas versus Brittany A. Kilgore. Jared Regier for the state. The defendant, Brittany Kilgore, has now joined us. It's 11:40 a.m. Ms. Kilgore, you were told to be here at 9 a.m. What brings you in so late today?
I did not know that I had court today or anything. I did not know.
How do you know now then?
I got somebody had mentioned about that I was supposed to be in here, so that's why I'm here now.
So someone you know called you and said, hey, they called your name in court?
No. Yes.
Why are you playing games with me? How did you find out you had court if you didn't know about it?
I was just told by somebody that, hey, you're supposed to be in court right now. They issued a warrant for your arrest, so that's why I'm here.
Well, I'm contemplating just telling you to turn yourself into the sheriff.
I understand.
How did you not know you had court today? Nobody told you you had court? Nobody served your paper?
No.
And Your Honor, the state would proffer the ticket in this matter, which does appear to include a notice to appear for today's date and time.
I do see that you were personally served a uniform notice to appear and complaint by the Kansas Highway Patrol on April 11th, 2026 at 8:17 a.m. You signed a personal recognizance to be here. Trooper Leanna M. Setzcorn handed you that. You don't remember that, or you just didn't read it?
I probably just didn't read it then.
All right, then you need to turn yourself into the Butler County Sheriff at this time.
Okay.
And we are in recess on Kilgore.
Next is People versus Anthony Dwayne Grant. That's you, sir?
Yes, Your Honor.
Mr. Grant was in the car with Kyle Sigler. He's Kyle's father. And again, I did watch the video of this. Mr. Grant is here with his lawyer, Mr. Ross Truckee. Also present once again is Angelique Canfield. Again, we have people that are not on the same wavelength. Mr. Sigler, for the most part, was quiet. Anthony was not. He's what got this all spun up. But even so, I don't know that the charges fit the facts. That's up to, I guess, a judge after they hear the whole trial or a jury. Count one was by threat, intimidation, discourage or attempt to discourage J. City Van Dyken from testifying. That's a felony punishable by up to 4 years imprisonment and a fine of up to $5,000. Maybe that was in the exchange. I don't know. It's hard to hear all of it. Count two is resisting and obstructing a police officer. Mr. Grant pled to attempting to resist or obstruct a police officer, and that matter is set for sentencing today. So when I talk about people that are not on the same wavelength, again, there may be something under my radar about what was going on at Myers. I don't have any clue about that. But from the four corners of this traffic stop, it didn't seem to be much of anything. And again, the car was driving down Lincoln, I think. Anyway, right in the tornado territory. This was just a few days after the March 6th tornado. This was March 20th. You could still see trees on the side of the road and stuff being picked up. As far as I could tell, I couldn't see any traffic violations. And they come upon the car, they pull it over on Broadway Street, and the defendant, Mr. Sigler, pulls over, he stops, and then he turns the corner to pull over on a side street, which frankly makes more sense. I guess they were on Millard. I was on Millard Street. And then they pulled over at Millard and Andrews, I think that street is. Anyway, they pulled. As I indicated, it appeared to me that both brake lights were working. And if a license plate was out, I couldn't tell because of the bright light shining on the back of the car. Deputy Van Dyken gets out. He starts to inquire as of Mr. Sigler, and you can hear Mr. Grant in the background. Let me say this, the cops hate this. People say, I want to call your supervisor. And this and this and this. They don't have time to call a supervisor out every time somebody gets pulled over on a traffic stop. So their perception is it's a traffic stop. Your perception is, here we are, driving, not doing anything wrong, and we get stopped by the cops, and we have certain rights. And I demand my rights, which you're certainly entitled to. So you ended up causing Kyle to get arrested for this. If Kyle would have just handed him the registration and said, I don't have my license with me, it would have not escalated as it did. It only took 2 minutes probably took about a minute for this to go haywire. Once again, I don't know that a juror would find resisting obstructing on these facts or intimidating a witness. I guess that'd be up to the jurors after they heard all the testimony. I read a part of the police report and I saw the videos. So the prosecutor knows more about this than I do. But the videos, I don't know if you were in here, they were hard to watch. Made me cringe. But it didn't really have to go this way. And it did. Mr. Truckee, what would you like me to know?
Thank you, Your Honor. First, I guess I'd like to read us a bit from the police report under a section titled Information. It's kind of a prelude. While on patrol in the area.
Your Honor, I guess I have an objection to this. The police report's not admissible into evidence at trial. It shouldn't be referred to or read into the record at sentencing either. I don't think it's appropriate.
Well, your objection's overruled. I routinely read the police report in preparing for sentence. This matter was negotiated as a plea. What is in there you don't want me to hear? Anyway, she objects, but I'll listen to what you have to say.
While on patrol in the area of Meyer, I observed a Chevrolet Malibu parked in the lot and observed 2 males exiting the vehicle and or attempting to get back into the vehicle. When they noticed my patrol vehicle driving through the parking lot, both males stopped what they were doing, entering or exiting the vehicle, and looked toward my patrol vehicle, back at one another, then back at my patrol vehicle before getting back into the vehicle. 2 men entered or exited a car in a parking lot. That somehow tips off the officer that he better be on the lookout. Shortly after, he observes the vehicle driving in a different part of town with the alleged no center brake light. Your Honor, watch the videos. I'm not trying to impute some sort of subtext here, but I have my concerns about this initiation of some sort of investigatory action by the state. This leads to the traffic stop, which obviously Mr. Grant, he had his hand on the thermostat just as well as the deputy did. The temperature kept turning up and up. It never did get violent. It was back talk and a rough day at the office for the deputy. Some might say that's part of the job. Not everybody you meet as a road patrol deputy salutes and says, yes, sir. And we don't have to in America. But Mr. Grant didn't. And it ends up with him being eventually stuffed in the back of a squad car, hauled off, charged with felony counts, including witness intimidation, which that was negotiated away as part of the plea deal. I found it an odd charge, but that's not what we're here for today. Mr. Grant has a history that Your Honor's well aware of. He's also got a history that I don't know that Your Honor's aware of. A letter of support was provided by Mr. Eric Schaefer, speaking out in support of Mr. Anthony Grant Sr. No, we've known him for around 25 years, first as a tenant in our apartment building and a tenant at a house in Three Rivers. Positive things to say, the Schaefers are here today as community support members. It's another letter from Mr. Terry Koviak with essentially similar things, known Anthony and his children for 17 years. They're a family that loves God and do what they can do to honor God while living in this time. Anthony's a single dad trying to provide for his family. He puts God first and his kids second, and he's never been one to put himself or his family in danger. He's a business owner running a construction business and an irrigation construction business. And then further, it addresses his children and their successes. Through his businesses, he regularly hires people that have been before your honor and are getting out of jail. He works to get them plugged in to celebrate recovery, which he credits with saving his life. He's a complex person. He's not just a guy mouthing off to a cop and being rude. He serves his community the way he can. This is a very unfortunate incident. I mean, we have a family that went out to dinner at Applebee's and went and got groceries at Meijer and then ended up charged with felonies. There are things he could have done differently. That's why he entered a plea in this case. But I think that the court can see the facts here and some of the other issues that may be at play. And I would ask the court to consider sentencing Mr. Grant to a time served and waiving any discretionary cost or attorney fees. Thank you.
Thank you. Ms. Campfield, again, I think you inherited this one, but do you have any additional input regarding this defendant?
Well, Your Honor, what I can indicate to the court is that you're absolutely correct. This is something that was inherited. I didn't authorize this, but be that as it may, I disagree that there is no attempt to put subtext into this matter by the reading of the report into the record. The deputies have a difficult job. They're trying to keep their community safe. When people look at the deputies, it's a little bit unusual. Usually they try to keep their eyes away from deputies when they see them. So that draws their attention to that vehicle. And then when they stare at them again before they get in, that caught Deputy Van Dyken's attention. When he sees the vehicle again, he observes a brake light out. So, that's the reason for the stop. I agree with the court that but for the interference of this defendant with Deputy Van Dyken's traffic stop investigation, this would have ended up in a citation and a quick appearance in court for Mr. Singler. Unfortunately, that's not what happened. It's excellent that Mr. Grant is now a business owner, has gone through rehabilitation, and has stayed away from substances, but he does have a history of substances. He has a history of a sexual assault conviction, violations of the Sex Offender Registration Act, and things of that nature, which are also concerning to this court, and a conviction for theft previously. So certainly he's not ignorant of the system, shall we say. He's been through it before. He's very familiar with the simplicity of a traffic stop, that if you just provide the information requested, it'll likely end in a citation. He escalated this. It was unnecessary. And then beyond just refusing to get out of the vehicle or to stay quiet so the deputy could talk to Mr. Singler, he then also refused to get into the patrol unit and was attempting to physically resist, albeit passively. He didn't strike out. He didn't kick at anyone. But I do think the court needs to be aware of that, as well as it probably already saw in the video. So I don't know if in this particular instance, just fines and costs and a night in jail is sufficient. I would request maybe a short term of probation, just to ensure that the SORA is up to date and all these other things are being complied with, as far as, maybe even some drug screens given his history. I don't think things would have escalated, and perhaps he was under the influence of a substance that night, which caused the escalation of behavior.
All right, Mr. Grant, you get the last word. Is there anything you want to tell me? You take your gum out.
Yes, Your Honor. Well, I've been around you for a little while. Here's when I came up with Three Rivers and stuff. And some of the history she stated is my past. but that's not my future. All right. I said through right now, some of these things she stated, that's not me. Some of them was me. I make sure that I do my best to stay away from this place instead of coming in and saying hi to you here and there. I recently, a couple of years ago, got a divorce. Things wasn't too good at home. I cleaned it up to keep my kids safe and keep myself safe. Could have went another way. You know, like I said, through the Celebrate Recovery program and having good mentors like the Schaefer's and the Koviaks in my life and the church I attend definitely has helped me to walk that line. We wasn't looking for anything that night, but to go out and eat dinner, to go out and eat and pick up some groceries. That's it. To me, the whole stop seems unlawful. The brake light was dim. That's all it was, the third brake light. But from this,
Well,
my
everyone
freedom
keeps
is
saying
finished.
brake light,
They said the third brake light.
but all right, the middle brake light. There was no middle brake light.
That's what it's
So
all
I didn't know if they meant the license plate light. As far as I could tell, the brake lights seemed to work.
But if I'm not trying to argue the point at Your Honor or anything else.
Right.
But if that's the fruit of the poisonous tree, was an unlawful stop, I shouldn't even be in this situation. I shouldn't even be here because I wanted to feed my family, because I wanted to go to dinner. I get tired too. I want to go out and eat like everybody else. But this officer seems to have something, and I don't know, there's just something that's not being addressed for his actions towards me and my family. So what if we look at each other? I look at him, don't mean I should get arrested. Jeez, I look at him. What does that have to do with me being arrested, spending 3 nights in jail? They took my money, they took my car. This is just, I don't get it. Where's the land of the free? To go to dinner and to eat. That was it too. To go to dinner and get some groceries. All of this from that. Thank you, Your Honor.
All right. I've known Mr. Grant for probably 40 years. I was prosecutor that handled some of those convictions Ms. Canfield spoke to. I do not believe Mr. Grant has been in any trouble since I became judge 24 years ago. As he indicated, from time to time, he'll just stop by and stick his head in and say hello. He's always respectful and continued to know of him for all these years, but I don't believe he's been in any trouble. I think in at least 20 years, maybe all 24. At any rate, if I had to disqualify myself every time I knew somebody, I wouldn't be able to serve. And so, although I didn't really want this case, I didn't feel the need to disqualify myself. And so here we are. So I know Mr. Grant from the bad and the good. I do not believe we needed a substance abuse evaluation. I think he's been drug-free for 20 years or more. He's active in the Celebrate Recovery community. He's active in Riverside Church and some other recovery communities. I don't believe drugs or alcohol had anything to do with this incident. But the cringe factor in this is it points out the disconnect between being a young white law enforcement officer and a black man driving a vehicle in 2026 St. Joe County, Michigan, coming at it from two very different places. If my wife and daughter-in-law were at Myers and they looked sideways at the cops and they looked at them again, that probably would be the end of it. So I don't know what all that was about. All I know is it came down to this. And for anybody here, anybody that's viewing, when the police pull you over, you have an obligation to provide your identification and automobile status, registration and insurance. Even if it's a questionable stop, and I'm not saying this was, but you have an obligation, and I said the statute that maybe most closely fits the facts for Mr. Singler is 257602. Ross said it pretty well. You had your hand on the thermostat and you turned up the temperature. You're coming at it from the perspective of a young black man with his son doing nothing wrong in your mind except driving a car down the road. Public roadway. As far as I can tell, there were no traffic infractions. Drugs or alcohol were not a factor. They didn't find any contraband. Neither one of you had open warrants. You're coming from Applebee's like thousands of people do every week. His perception is, well, let's see what the deal is. And Kyle was mostly quiet, but you were trying to give Kyle bad advice. The advice is just give him your license and information. But that might be a bitter pill. Like, here we go again. So the disconnect is between the officer's perception of this and your perception of this. There were extrajudicial sanctions that your car got towed and impounded. You had to pay to get it out of impound. You had to pay a bail bondsman money to get out of jail. That's money you won't recover. So that's over and above anything I do. You spent 3 days in jail. I don't know what a juror would have made of this. Guess we'll never know. But I wish it had gone a different way. And I can't take back anything that's already happened. It all already happened before I even touched the file. You already did 3 days in jail. You already got your car impounded. You already got a bail bondsman to bond you out before I ever even had anything to do with it. Sometimes that's what happens, but I'm not going to do any more. I'm going to do 3 days jail credit, 3 days. I'm going to do a $25 fine, and I'm going to waive the attorney fees just like I did in Kyle's, $200. But I do think your temperature gauge got Kyle arrested, and you. Can you pay that within 30 days?
Yes, Your Honor.
All right, you're all free to go. I'm glad this matter is resolved, but don't have an answer to the ultimate question here. How disconnected we are. All right, you're all free to go.
Yeah.
Thank you, Your Honor.
Thank you.
25. Thank you. Okay.
Sir, take care of yourself, all right?
Thank you.
All right. Let me know if you ever need anything.
All right.
Now, Keith, I don't know what to expect from our next defendant. It's Elizabeth Conway, and TJ is here because he specializes in the Elizabeth Conway cases. I don't know how she's doing. I asked the jail staff, and I don't think she's doing very well. She has $775 worth of unpaid fines. She has 3 failed to appear trespass cases, which I'm also going to arraign her on, and a new disorderly person case. The next pre-trials would be next Friday, the 26th. The last time I saw her, I had some serious concerns about her competency. I did some plea and released her, but I don't know what she has for an address. I saw James Roberts this morning. He's kind of in the same boat. He didn't really want to see me very much, so he walked out. Good afternoon, Miss Conway. This is Judge Middleton. Can you hear me?
Yeah.
Also here with me is Mr. Keith Stickley from the Public Defender's Office. You have 4 separate cases that I'm going to address here in a moment. Also present is the Three Rivers City Attorney's Office staff. You got arrested last night on a charge of disorderly person.
Yeah, you can put it in.
They issued a warrant for your arrest, alleging that in April, you were a disorderly person, John Wagamood.
It's a very story.
Anyway, that is a misdemeanor under Three Rivers City Ordinance, 90 days and or $500. Then you kept getting charged with trespass, and then you kept not showing up. So you have 3 trespass cases.
When are you ever going to offer a PR bond? Last time I learned you let you steal free.
Well, I haven't got far yet. But the problem is, you often don't show up when you're supposed to.
I'm not a victim of crime in this county. I'm not going to be telling you I'm not. No, not happening. You're not going to talk to that guy. Right. Oh, right here.
Thank you.
Elizabeth, how did you get arrested last night?
Just sitting on the porch.
Where are you staying?
Oh, I was in Florida.
Say that again.
In Three Rivers.
Where?
In Three Rivers.
I mean, where were you sitting on the porch?
117th Street. 117th Street.
You're not supposed to be over on 7th
Right where I
Street.
was molested when I was a teeny baby. I was in a 6-year, 6-month home. So I had to suck a dick when I was a 10-month-old baby in this county. The same address. Right there. October 1986. I was only a 10-month-old baby.
All right, you got evicted from that house.
I never commented on that house. I don't want to hear it.
All right, so they arrested you last night?
Yes.
All right, because of this warrant. Is that correct?
I don't know. I don't want to hurry up, please.
Now, you also have 3 trespass cases.
Boy, I tap law because they hurt my brother, Michael Bigeman. My volunteer brother, Michael Bigeman. state trooper said that I hired in the county?
Elizabeth, I'm having a really hard time understanding you.
That's fine. Can you just do the silence thing too? Because my lawyer's gonna have to go to you soon again. Whenever if you don't give me a paper by today.
Give me a moment. Anyway, they allege that you trespassed in Three Rivers on April 8th. Excuse me, May 8th. That's file number 26906SM.
You carry out.
On April 23rd and file 26746. And on May 12th.
That's not why I got arrested. It's not why I got arrested because I know you're not doing something right. I got arrested because I had a disorderly person from Myers, but I went in there. Officer Bowen tried doing it because the state trooper. I'm the one that. You could just keep me in here if you want. You never give me a PR bond, so I just want to know you're gonna lose your job today. I just want to let you know that state troopers are gonna make sure you're fired. I watched you on camera kill one of my mothers, so it's not gonna happen. Nope. Come on, hurry up, please. I don't want to lay the book down, please.
Your Honor, I don't know if I've had extensive experience with Miss Conway. Sometimes there's
You
obviously
remember my mom treats Bingaman, right? You know my mom
something
treats
else.
Bingaman, right? You know my mom treats Bingaman. Charles didn't come and Junior's my dad. You think I'm my mom? Charles didn't come and Junior's my dad.
All right, Elizabeth, I'm gonna.
Oh, I'm sorry. Go on.
Well,
I'm gonna
she's the
go.
second
I
person to walk
don't care
out.
what else. You don't have tie. And what a killer.
All right, Elizabeth, I'm gonna appoint a lawyer for you on all of these cases. And we're probably gonna have to solicit a competency evaluation again. You've been to the forensic center and it takes months and months and months, but.
No, I'm pain right now. You're gonna shut the fuck up.
Yes, I am. Well, you guys gotta decide what you wanna do with all those, but according to things, she kept peeing in the alley, the Mural Mall alley, the nice little cut through the parking lot that they're trying to keep nice. She and some other homeless people are hanging out in there and peeing in there, and that's not good. As we know, they don't prefer to do a competency evaluation on trespassing cases, but I don't even know how to go to square one with her. I'm going to show a plea of not guilty in all cases. I didn't understand much of what she said, but I did understand when she told me to shut the F up. Show a plea of not guilty, all files. Appoint an attorney. Set attorney pretrial for 6/26/26 at 8:30. $250 cash or surety per file. I never even exactly understood where she was. The legal department of the city of Three Rivers can decide how they wish to proceed. I took a plea in a case a while ago. As I said, I don't even know that it was a competent plea, but I let her out of jail. But she has nowhere to go and she's not well. All right, gentlemen, you saw what I saw, so we'll let you guys work with whoever gets appointed a representative before we have the pre-trials. Thank you, Mr. Stickley, for your help.
Shannon Sherrill Phillips, 26B150905 A and B. Your name? You're charged with resist, hinder, and obstruct an officer. 2 counts. You have the right to an attorney. I'll be happy to provide you with one at public expense. Would you like a lawyer? You waive your right to a lawyer?
Yes.
So I'll go ahead and arraign you. I'll set bond. You asked for my oath of office. You can approach John, give him my oath of office. You also have a motion here that I will address after I arraign you. It is alleged that you did commit the offense of resist, hinder, and obstruct an officer on April 29 of 26, at or near 23125 King Road in Brownstown at 12:01 p.m. That is count one. Count two alleges the same count. Resist and obstruct an officer or misdemeanors punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that? I can't hear you.
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty at any time, you'll be giving up all of those rights, and we're not going to have a hearing or a trial. Do you understand that? You still wish to waive your right to a lawyer? I will enter a not guilty plea. You acknowledge receipt of that oath of office?
Yes.
Okay.
Thank you.
You argue that you don't have to go for fingerprints, right? You filed a motion here. Emergency objection to fingerprint compliance deadline and request for stay pending adjudication.
Yeah, well, I was trying to figure out, you wanted fingerprints for this charge? I filed a motion because I was literally assaulted by the Brownstown Police Department when I went there to get fingerprinted the last time.
On another case, right, in front
Yeah,
of judge?
the initial charge is what I was there for fingerprinting for, yes.
All right. I didn't order you to get fingerprints on this case. But I am gonna order you to go get them fingerprinted now. I'm gonna order I'm gonna give you a $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law or ordinance.
I feel for my safety.
Yeah. Let me finish. You're not to have any contact with the victims. If they happen to be the one fingerprinting you, that's one thing. Otherwise, you're not to write them, phone them, see them, text them, email them, or have any contact with them whatsoever. You're not to possess firearms. You're not to possess dangerous weapons. You're not to have any contact with prosecution witnesses. I'm going to order that you go over to Brownstown by 1 p.m. today to get fingerprinted and photographed. That's a condition of your bond.
The victims.
Let me, would you please stop? Let me finish. You're not to have any contact with the victims.
The victims are the Brownstown Police Department.
That's their allegation. I don't know what happened, man. I don't read police reports unless and until there's a conviction, but I am ordering you to go over there and get fingerprinted and photographed by 1 p.m. today. In the meantime, I'm going to send you to the prosecutor. You can discuss the case with the prosecutor, and we'll go from there.
Okay, so if I'm not supposed to, like, what am I supposed to do when I go there? Who am I supposed to actually talk to?
You're supposed to, you're going to take the order. We're going to fax over the order. And you're going to take your bond sheet and you're simply going to cooperate and tell them that you are there to be fingerprinted and photographed. If the individuals with whom you had the issue are, how do I say this? If they're the ones fingerprinting, that's not going to be deemed a violation of the no contact order. Okay? You understand what I said? In the meantime, you can go talk to the attorney, the Brownstown Township attorney, see if you can resolve this. If you can't, we can set it for trial, okay?
So you said talk to the prosecutor?
Have a seat in the hallway.
Yeah, hang on. Yeah, you're gonna go talk to the prosecutor. You said you want to represent yourself.
Yes.
So you'll go negotiate with the prosecutor. You can explain your position to her. Maybe you can get her to dismiss it. I don't know. And if not, we can set it for trial.
Okay,
Okay?
thank you.
All right, see you back in here after you've talked to her. Jacob Michael Douglas.
Nothing hearing there, 9:45.
Ma'am, come back up here.
Okay, you said come back after I talk to the prosecutor.
Come back here after you talk to the prosecutor. If you have a hearing in front of Judge Heston, is that what you're saying?
Yes.
You'll go there after you're done with me on this case. Okay? That's all right. Derek Arthur Eshelman, 260-148-944. Mr. Hogan, you can come on up here, sir.
Morning, Judge. The 82378 on behalf of Mr. Escher.
Your name, sir?
Derek Usselman.
Sir, your name?
Anthony Mulder.
Prosecutor offered a plea to assault and battery under section 771.1. I asked for the video, and apparently it no longer exists at the McDonald's. The might have captured the assault, none exists. That's where they are. I'm not, let me just put it to you this way. You better make this one good. Not that you always don't. You always do. But I don't go for this. So, is everything in this report accurate?
Yes, Your Honor.
I'm asking, any material additions, corrections, or deletions?
There's no additions, deletions, or corrections.
What would you like to tell me? And by the way, did you get a chance to read this victim's rights statement?
No.
Well, can I read it to you? And if you need to talk to your client about it further, I will. I was shocked and terrified when the crime occurred. I was slammed into the ground and kicked in the face. As a result, I was taken to the emergency room by ambulance, and the doctors told me my rotator cuff was torn on my right shoulder, which is my dominant arm. My right shoulder was dislocated and my nose was broken, as well as swelling and bruising around my arm. I couldn't see out of my eye for a long time, and my arm was in a sling. I possibly need surgery on my left eye after seeing an eye doctor. I also may require surgery on my shoulder.
I think my charger's in your car.
Can you? I also may require surgery on my shoulder, and I go to physical therapy 2 days a week as a result. My glasses were broken, so I had to pay for a replacement. I think it says pour, P-O-U-R. Oh, pair. I'm sorry. I'm in pain and I can't enjoy things like I was able to before. I'll face lifelong pain and suffering from this assault. I'm scared of the man that did this coming after me again. I hope the man that assaulted me is punished with the full extent of the law. I needed assistance going to appointments as well as daily chores. I lived alone and was independent before this, and I had to ask for help from family. I had to ask for help writing this because it hurt too much. I've also suffered financially due to bills and paying for a replacement pair of glasses. Medicaid only covered a portion of my medical bills, and I do not have enough money to pay them. I've suffered physically, mentally, and financially from this assault that has affected my family as well. We're more on edge from this. I hope justice is well served in this case. So I want to make sure I understand. We're going to come to you in a second, Mr. Hogan, and I want to hear some and see any documentation that you may have regarding your injuries and any necessity of surgery. So go ahead, Ms. Patillo. Have you had a chance to review the report? I know you already said there were no additions, corrections, or deletions.
We did review the report, Your Honor. There are no additions, deletions, or corrections.
Anything you would like to say on his behalf?
Yes, Your Honor. So Mr. Asherman, he is employed and all that, as you can see in the report, he has a child, Your Honor. I know that last time we were here, there were some things put on the record about the Army and different things like that. Mr. Eshelman was not saying that in defense or self-defense or anything like that.
He was saying is the instincts that he gained from the military caused him to do this. And by the way, he fled the scene too, right? Did the military teach him to flee the scene? But anyway, go ahead.
So he made those statements for different reasons. He is very apologetic for the situation. He's very apologetic to what Mr. Hogan has had to go through. He's, understands that he may be on the hook to pay some medical bills or things like that, whatever Mr. Hogan was able to produce. But again, Judge, he is very apologetic. He was very apologetic when we spoke. He wishes he could take it back. I know Your Honor may be considering jail time. I would ask for you to forego any jail time because Mr. Eshelman is very apologetic in the situation. He also needs to keep his job. If Mr. Hogan does need restitution, if the court is satisfied with whatever Mr. Hogan presents in terms of medical bills, his glasses that need to be repaired, things like that, Mr. Eshelman will have to pay for that. But if he loses his job, obviously Mr. Hogan would have to wait longer, Your Honor. So I would ask that the court would consider following the recommendation and maybe just order more days on the court work program in lieu of any jail judge.
Anything you would like to say, Mr. Eshelman?
I just apologize to him. It was a complete lapse of judgment on my end, and it would never happen again. I accept full responsibility for what I did.
How old are you, Mr. Hogan?
67.
How old are you, Mr. Eshelman?
37.
What would you think of him if he kicked a 97-year-old in the face? I am troubled by this. Very troubled by this. I don't like assault cases. And honestly, as far as I can tell, you were acting nothing more than like a bully. I don't like bullies. I didn't like bullies when I was 12, and I don't like them at 67. You have any medical reports?
I just have an imaging order and I have to go and get another ultrasound on my arm, but it does state rotator cuff and.
What kind of injuries have the doctors told you that you have? You're in a courtroom, and I want you to be completely honest with me.
I had a dislocated shoulder that night, opted back in. I have a torn rotator cuff with ligaments and a chip bone in the shoulder. I had nasal bone fractures and an eye socket bone fracture.
Orbital bone?
Yes.
Yeah.
And I have to go back, I think July 24th, because this eye droops and it waters like all the time. I have to go back and see. And right now I'm in physical therapy because the Dr. Siskowski out of Royal Oak, or where is it? Michigan orthopedic surgeons. He wanted to see. You gotta take that phone out of here.
The phone has to leave the building. Ma'am.
It's gotta go.
It's gotta go. Please take it out.
Off your car.
Ma'am, take the phone out of the building.
He wants to see if there's between the MRI and physical therapy and ultrasound, if he can tell if there is an additional tearing with possibility of surgery. I believe right now he is trying to not do surgery, and I would rather he didn't. I'm 67 and not playing baseball or anything anymore, so just in my daily.
I want to make sure I understand how this happened. You were in the drive-through, right?
Yes, I was in the outside lane. There was two lanes. When I pulled up, the first lane was occupied by two vehicles, and I pulled to the outside. And the first vehicle left, and they took my order. When I went to pull to the pay window, is when Mr. Ishman pulled forward in front of me into the pay window and was complaining to them that he was next. And
Then he backed into your car?
then we went to the pay window, so our orders were offset, so they had him pull ahead. And I noticed when I got to the pay window, he had pulled ahead, and his reverse lights were on. So I beeped the horn, blew my lights at him and hollered out the window, don't back up, you're in reverse. Because some people, when they pull forward and they go back up, they,
Right.
and slowly, it was no fast hit, but it just slowly, I don't know if he took his foot off the brake or wouldn't pay attention, I like, but it backed into my car. And so I got out, was just gonna, and I said, he just backed into my car. It's like, or my truck. He's like, he gets out and he says, well, show me where I backed into your car, tough guy. And I went to turn like this to the front of my vehicle, and it had snow on it and stuff, because it was, the next thing I knew, I was pushing to. I don't know if I hit.
I'm sorry, say that again. Next thing you know what?
Push. I don't know if I hit the front of my bumper or the ground. I ended up on the ground, And I couldn't get up because my arm was, you know, pressing wake myself up. And that's when I was kicked
Kicked where?
in the face.
How many times?
Once. Glasses were kicked off. The people came out from McDonald's, seen me laying on the ground. They thought I had gotten run over in the drive-thru. And they asked if I needed a police or ambulance. And I said yes. And then I don't know if he ever got his order. He ended up leaving and the police came, the ambulance came. Took me to the emergency room.
What kind of out of pocket do you have? Restitution?
I had a list, but it was turned in.
Have you received all the bills regarding all the treatment that you've had?
So far, yes. Glasses, I have, prescriptions, co-pays, most of my insurance.
I'm gonna set a restitution hearing a couple months out. And I'm gonna have you get everything together. And you are going to send it to the court and to the defense lawyer. Actually, we'll call him Ms.
I think.
Well, hang on, we'll call him Ms. Foley Carter. Yeah, I know, but you're still going, right? And I want to make sure that everything's covered. And what isn't covered, I'm gonna order him to pay.
You know, as far as the therapy, I just have my schedule. Would you like a letter from me now?
How many times are you going to, how many times are you going to therapy?
Twice a week.
Your name?
that.
There's gonna be an issue of restitution. I'm having him get bills together. We're gonna set a restitution hearing in about 2 months. Okay?
Understood.
And I'm gonna have him send everything to you. And I'm gonna ask you to forward it to the court and to Ms. Patillo.
Yeah.
Okay? So give me a restitution hearing date when I'm done here, Heather. Anything else anybody wants to say, I'll be glad to listen. Anything else, Mr. Holt?
Yes, I just, you know, basically what was said in the first report, and I just, you know, kind of rewrote something, you know, about, not being able to do the things I did do and stuff. And having to rely on my children for help and stuff, which I would live alone, I'm very independent, I don't like asking for help and stuff. I understand Mr. Eshelman was either having a bad day or something, I don't believe that's his everyday character, I hope not. But I do ask for your judgment on his punishment. And I would like to tell Mr. Eshelman that I can forgive him for his actions. And I said, I'm 67 years old, I don't think I was that big into it.
I don't either. You, never been convicted of anything. They're going to take us under section 771. I'll do that. I want you to understand me, Mr. Esham. I have nothing but the highest respect for people that served in it, that serve and have served in our military. You almost insulted the military when you made the statement to me at the last hearing. My military training kicked in. Now, if you were in Iran and this happened, that'd be one thing. You were in a McDonald's parking lot and you're worried about who's going first through the drive-thru. You've got to be kidding me. And you get out and assault a man who's 30 years older than you, that clearly is not as strong as you. You should be ashamed of yourself. I just don't understand this. I don't understand the anger that goes on out here anymore. The animosity among people. I just don't understand it. Like if we all were gonna live till we're 1,872 years old, maybe we could afford to act like a jerk now. This is a short life we live. And I just don't like the tough guys. I just don't. You beat up a man 30 years your senior. You kicked him in the head. I saw the pictures. I've read the statements. I read the reports. You left the scene after this. You knew you did wrong, and somehow, some way, you justified and tried to rationalize it last time on the basis of military training that kicked in. I don't relish sending first offenders to jail. I really don't. 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No contact with the victim, Dennis Hogan. You cannot write, phone, see, text, email him, or communicate with him, or have anybody else do any of those things for you or on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve an anger management program with 12-week follow-up. I'm going to set a restitution hearing. We're going to give you a date on that, and we're also going to give you a prosecutorial review date. And you're to pay restitution as ordered following the hearing. We're going to give a date on the restitution, Heather, in about 2 months. Do you understand the sentence of the court so far?
I do, Your Honor.
And you didn't serve any time in jail at all, correct?
I do not, Your Honor.
This could be a lot worse. I'm gonna order 25 days jail. I'm gonna let you serve 7 days on the court work program. There's a $35 a day charge for that, for a total of $240 to $245. You're to serve 18 days jail forthwith. You're to pay fines of $200, costs $275, victims each break fee, $50 justice assessment. Now I'm gonna go up. I'm gonna go higher than 400 fines. 200 costs, 75 victims' rights, $50 justice assessment. That's 7.25. Screening fee is 60 for 785. Probation fees are 240 for a total of 1,025, plus attorney fees of 40 for 1,065, plus court work program fees. Your total here amounts to 1,310. If you that includes the 7 days on the court work program, you're going to pay restitution as ordered following a hearing. The restitution date will be when, Heather?
We could do August 20th.
Will Ms. Patillo be here that day?
Oh, actually, she will not. We won't have her again until August 26th.
Then let's set it after August 26th.
All right, so we could do August 26th. Then you want to do 8:30?
Yes, August 26th at 8:30. You're to forward all the medical bills to Ms. Foley Carter, sir, Mr. Hogan, by August the 7th. I would like you to appear here as well. And give me a prosecutorial review date where this case would be dismissed on motion of the prosecutor if you're compliant. That has to be before June 17th of 27. Heather, what day am I going to have for that?
That will be the 27th calendar. That could be June 9th.
June 9th to 27 at 8:30 will be your review hearing date. We'll give you paper notices on both of those. I want you to understand something. This could have been a lot worse. This is a first offense, and you've never been in trouble, but that's it. I'm sorry. You're in custody for the next 18 days. Good luck. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer. For purposes of appeal, you should have thought about that before you kicked this man in the head. Have a seat.
Yeah, may I speak?
No.
This way, sir.
If you want to speak, I'll let you speak. I'll probably change my mind and make it worse. Do we understand one another?
We do, Your Honor.
If you want to speak, I'll let you speak, but I'll probably change my mind and make the sentence worse. Do we understand one another?
Yes, Your Honor.
All right, have a seat.
Come on, this way.
I'm taking a 5-minute recess.
Your Honor,
Who's on? Who? What? Ms. Ford, I'll be right with you. Give me a second. I'll be right with you.
okay. What took off the,
Natalie Brown. Call in Jessica over there, 245. Natalie Nicole Brown, 26F245-755B. And I also have 25F258-9442.
Good morning, Judge and staff. John Graziani, bring up behalf of Natalie Nicole Brown.
Your name, ma'am?
Yeah.
All right, so I do have a probation violation on an assault on a charge that was reduced to disturb the peace. It was taken under HIDA on September 4 of 25. There was a no contact provision in there. Among others, no contact with Solomon Knighton. And then I have a charge that defendant failed to complete the anger management program with 4-week follow-up on that charge, and also failure to refrain from having contact, direct or indirect, with Solomon Knighton, and also failure to refrain from violating a law, to wit, pleading guilty to destruction of property on April 30th, 26 through this court. That's the charge for which she is in here for me to sentence her on. But, so essentially here, we have one technical violation and 2 non-technical violations, violation of the no contact and commission of a crime. So with that, counsel, have you had a chance? I don't know which direction I want to proceed first here. Give me 1 second. Just give me 1 second on that, please. I don't know which direction I want to proceed, but I think maybe we should address the probation violation first.
Absolutely, Judge.
Ms. O'Donnell, your name?
Just go on.
All right, so what is she going to do on that?
Judge, with regard to, failing to attend an anger management program, she pleads guilty through that with an explanation, sir.
That's count 1.
That is correct.
And what about the failure to refrain from having contact and violation of the law?
Judge, it's a little bit sticky here because of the fact that this is made for DV sitcom. She lives in the same complex as her ex does, and she has indicated to me that she uses her ex's mother to pick up the children. So in terms of indirect contact, she is guilty, but she is not flagrant.
On this other case here, she broke into his apartment.
That was the separate case, Judge. That's a separate one.
But that's the one that she's being violated on. That's the one that she's alleged that there's 2 things here. She's alleged to have committed a destruction of property, which is the violation of the law set forth in count 3. And I'm presuming your name, that was the basis for the failure to refrain from having contact.
That's correct.
So the fact that she broke in, had contact with him, committed an MDOP, that for which she pled guilty on the MDOP, that forms the basis for these 2 charges.
I thought you were addressing that. She's guilty. Is that correct, ma'am?
Yes, I'm guilty.
Hang on. So let me take your plea then. So if you plead guilty to failure to complete anger management, you could get 5 days. Plus you had 1 technical violation, so you could get 10 on that. On that charge, as a result of this, you could get 90 days if you plead guilty to failure to refrain from having contact and violation of the law. Do you understand that? You have the right to a hearing on these. At that hearing, you have the right to bring in your own witnesses, to use the subpoena powers of the court to bring in those witnesses, to testify or remain silent. If you remain silent, that silence would not be held against you. At a hearing, you have the right to question their witnesses, cross-examine them. Bring in your own witnesses using the subpoena powers of the court to bring in those witnesses. Do you understand that?
Yes.
If you plead guilty, you're waiving all those rights and we're not gonna have a hearing of any kind. Do you understand that? All right, to count one that you failed to complete anger managed with 4-week follow-up. How do you plead? You failed to complete anger management with 4-week follow-up.
Yes.
I gotta have you speak up.
Yes.
Is the count 2 that you failed to refrain from having contact, direct or indirect, with Solomon Knighton? How do you plead? Failed to do that. In other words, did you have contact with Mr. Knighton after I ordered you not to have contact with him?
Yes.
To the charge you violated a law or ordinance, being convicted of MDOP, offense date March 29, 26, while you were on probation on this case, and pleading guilty to that charge on April 30th, 26. How do you plead to that? Were you in fact convicted on April 30th, 26 of MDOP, malicious destruction of property arising out of an offense that occurred on March the 29th of 26?
Yeah.
Anybody in the world force you to plead guilty? All right, I'm gonna accept your plea to those 3 charges. You had 1 prior technical violation. So now you have 2 total, and you have 2 non-technical violations for which there is no limit to the amount of time that you can be given up to the maximum. So do you understand all of that?
Yes.
All right. Let's start now. Did you review the pre-sentence report with her, and are there any material additions, corrections, or deletions?
Judge, I did no material deletions or corrections to be made.
Anything you'd like to say on her behalf?
Judge, like I said, this is made for a sitcom. They live in the same apartment complex. Other than this,
So by the way, is a Solomon Knighton here? Either on Zoom or in person? Go ahead.
Judge, they live in the same apartment complex. Other than this unfortunate incident of malicious destruction of property, the contact that's been maintained with Mr. Knighton is through his mother to pick up the children and drop them off at Mr. Knighton's residence. That's what's been happening over here. Mr. Knighton has a significant other in his life. My client, Ms. Brown, wants nothing to do with them. She has a lot of challenges to deal with, particularly one of her children who's autistic, so her hands are full. She also helps out her mother at the residence, and she intends to start classes in the fall at Wayne County Community College. With regard to the anger management, even though it's a separate issue, Judge, her children were sick at that time, and she planned on taking care of that within the next week.
Can I tell you what I'm gonna do? I don't know what you're thinking, young lady. You know the right to break into somebody's house. You better get your anger management done.
Let's
I am still participating in anger management.
You're not doing too well. I'm gonna give you some time to go complete that. Give me a sentencing date when Mr. Graziani is here again.
It's taken under hideout and she is scheduled for a prosecutor review June 25th. Just so you have that.
Well, I have no choice but to revoke that status.
Judge, if you can, please consider not revoking it. I realize it sounds like she's been pretty bad, but the fact is she has tremendous responsibilities. The situation in the apartment complex essentially sets this young lady up for failure. I mean, it's, like I said, even the drop off of the children, I'm surprised more incidents can occur. They know about it.
Listen, I admire your advocacy here, but she didn't do what she was supposed to do. I gave her 10 months to complete I placed her on probation for 10 months in September. This is June. She hasn't completed her anger management. She violated the no contact provision, and she went out and committed another crime. I'm sorry. I'm going to go ahead and set a sentence. I'm going to set a sentencing date on this in a month. I'm entering the conviction, revoking her HIDA status on that charge, the disturb the peace, which the prosecutor was gracious enough to give her. We'll set a sentencing date on that, and I'm going to sentence you anew on that. I'll make a note, HIDA status revoked, set sentencing. I'll set the sentencing on the other case. We're going to give her about 4 weeks, and hopefully she'll do this. Okay?
You're referring to the anger management?
Yes. Give me a date.
And you want this when Mr. Graziani is here?
Yes,
Could you tell me, Mr. Have the July calendar? Can you tell me when you're
July.
here?
I could check my record,
I'll tell you what, you go down, you check your record, you take her down and you guys give your,
thank you so much, thank you.
people against Gregory Lynn Sorrell, file number 26784341. Mr. Sorrell, you'll have to get them to help you start your video and state your name, please.
All right now I am. Hello, Judge McNally.
Good morning, Deputy. Mr. Sorrell, your name?
Gregory L. Sorrell.
Mr. Crawford?
Michael Clark, Representative Sorrell.
So I understand this is going to be a plea of guilt to trespass, true?
That is correct, Your Honor.
If you plead guilty here, sir, the possible penalties are up to 500 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
Did you sign I'm sorry, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights. You're waiving your right to a jury trial. You're waiving your right to a trial of any kind. Do you understand that?
Yes.
To the charge of trespassing, how do you plead?
Guilty.
On June 11 of 26, we at 22482 Allen Road in Woodhaven at 8:50 p.m.
Yes.
And that was a Subway, right?
Yes.
And you'd been trespassed from them, told not to go back there by their owners and management, correct?
Yes.
But you went back anyway, right?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
Plea is accepted to trespassing. I'm ready for sentence, I think.
You're up. My client has been incarcerated for 7 days.
I know, but you know how many times he's gotten trespassing tickets?
I understand that he's had numerous contact with police, Your Honor. He swears this will be his last time. He understands he should not have returned to Subway, and he will conduct himself accordingly. He's got some bright future plans for himself.
He's always telling me, where's he going with his mobile home?
Sir, I'm getting my Social Security right now. I'm gonna be 66 years old this July 9th, and I'm getting
Mr. Sorrell, you have been in front of me and Judge Hessen a countless number of times.
Oh man, here we go.
All right, I won't say anything. I'll just go ahead and sentence you. If you're gonna keep doing it and doing it and doing it, if somebody wants to think I'm a bad guy for putting you in jail for trespassing, that's too bad.
Getting 2 houses. I'm not gonna do it. I'm getting 2 houses.
I've heard it.
But I am getting 2 houses. I don't lie. I'm about God, man. I witness to people all I do. That's why.
Sentence to the court that you serve 45 days jail, credit 6, serve 39 more. You're gonna stop doing this. You have 21 days to appeal, 14 days to apply for a fourth point more for purposes of appeal. No fines, no costs. Shut them off.
Gave me 39.
39. Yes, I did, and I'm gonna give you 90
You know what?
next
Your
time.
dad
Knock it
was
off.
way better.
Shut
Your
him
dad
off,
was way
Heather.
better than you ever dreamed to be as a.
He's gone, Judge.
He's gone. He's gone. Oh, I didn't open the camera. Oh my. You know what? Your dad was always better than you. I can't hold it together. I can't. Oh my dear Lord. Hold on. Let me reorient my Wolfie. There we go. You know, but from calling the judge an a-hole after getting served with his time to telling the judge that his dad was always better at his job than he was. Here's the thing to really observe with that, right? So the guy's been getting in trouble in that general vicinity for so long that he remembers what Judge Dad's dad was like sentencing him. He was sentenced by Judge Dad's dad. He's that much of a frequent flyer. You can't make this stuff up. Ladies and gentlemen, we've seen him a lot, but that's a revelation I never thought I'd get. The guy's been getting in trouble so long in Woodhaven that Judge McNally's father was sentencing him. He has personal experience knowing what Judge Dad's father's sentencings were like. It's great. It's great. You can't make that stuff up. Kids, I just want to say thank you to everybody. Start those credits rolling. I need to get my little, where's my list at? Marty Duvall, Mary Beth, Natasha Kitty, thank you so much, all of you. Uncle Salty Jowls, thank you so much. Northwest, wherever you be out there. Tona Clark Dobby, Natasha Kitty. Did I say Natasha Kitty? Natasha Kitty. I like saying Natasha Kitty. I don't know why. It's fun to say. Wixom, great to see you out there. Great to see you, Pete Nebrick, Jay Ferry, Terry Bosworth. Where's that John fellow that was here earlier? I hope you're still out there somewhere. Hope you all enjoyed the cases that I found and put together for the day. Started things off with another civil case today. A little weird one from Lansing, where a guy was really not happy during the mayoral primaries going on there, and it seems like he got himself in a little bit of hot water. And Judge Aquilina sounds like she's in position to just sanction everybody in this situation. And then, I mean, we go from that directly into, Kansas and all that Kansas is, and dealing with a Kilgore that can't read. Listen, people, if you're in Kansas and you get a speeding ticket, make sure you read those speeding tickets and make sure you show up to court, because Jay Regier is there somewhere and he will get you. He will put a warrant out for you, and Judge Webster will say yes. And you'll have a warrant for not going to court for a speeding ticket. I'm your lone wolf Usul, and I am out. Well, oh, hey, look, the wolf started moving again. I was about to say the wolf stopped moving. Start working. Remember, no matter where you are, there you be. Felix says Bueller. What does that mean? Oh, yeah. I don't have anything else. I'm not sure why you're here, but I'm done. Bueller. More specifically,